The city of Lübeck in 1981 was a picture of West German order. Its cobblestone streets and medieval gates represented a society governed by strict, predictable rules. Inside the local courthouse, that order was supposed to guide the trial of Klaus Grabowski. The legal system relies on these sterile environments to remove emotion from the equation and deliver a verdict based on evidence. That environment vanished in seconds. During the proceedings, a woman in the gallery stood up, drew a pistol, and fired 8 times. The muzzle flashes illuminated the room as the defendant was killed instantly, right in front of the judge. The courtroom is the one place where citizens are expected to trade the impulse for personal retaliation for the promise of a collective verdict. Those muzzle flashes signaled a total collapse of that agreement. The shooter was Marianne Bachmeier. The man she killed was the person accused of kidnapping, raping, and strangling her 7-year-old daughter, Anna. Grabowski was a convicted sex offender who had already spent years in psychiatric care. The details of what he did to Anna were horrific, creating a level of pain that the public struggled to even discuss. A criminal trial processes trauma through a slow series of motions and testimonies. It demands absolute stoicism from the family. But for a grieving mother, that trauma doesn't follow a court schedule. It remains a constant, immediate emergency. A trial can verify a timeline or a DNA match, but it has no protocol for a parent's grief. The legal process is built to resolve a case, not to mend the person who survived it. After the shooting, the state was forced into a strange position. To uphold the law, they had to put the grieving mother on trial for the murder of her child's killer. Legally, she brought the gun and fired in public, a clear case of premeditated murder. Yet the court had to weigh this against the circumstances. Her daughter's traumatic murder created a provocation no judge could ignore. Prosecutors were caught in a bind. A full murder conviction would be seen as heartless, but letting her go entirely would suggest that the law no longer applied if your cause was sympathetic enough. The court had to find a specific legal path that could penalize the violence without dismissing the tragedy that drove it. The solution was a legal pivot. They abandoned the murder charge, pursuing a conviction for manslaughter instead. Manslaughter provides a way for the law to acknowledge diminished capacity. It recognizes that extreme emotional duress can push a person into a state where they are no longer in full control of their actions. Marianne was eventually sentenced to 6 years. Because of the time she had already served and her behavior in custody, she was released after only 3. The manslaughter verdict served as a legal compromise. It allowed the state to punish the crime while quietly showing mercy to the mother who committed it. The verdict didn't end the controversy. Instead, the story moved from the courtroom to the front pages of international newspapers, sparking a massive public debate. To many, Marianne was a hero. They saw her as a mother who had delivered a necessary consequence to a monster, filling a gap where the legal system's punishments felt too light. Others saw a threat to the foundation of society. They argued that if individuals are allowed to decide who lives and dies based on their own pain, the rule of law becomes meaningless. The debate was no longer about whether she pulled the trigger. It was about whether a civilized society can survive if it allows the victim to become the executioner. Decades later, the Bachmeier case remains the most famous example of courtroom vigilantism in history. It highlights a gap that the law may never be able to bridge, the difference between the objective justice the state provides and the internal closure a victim actually needs. The law requires us to trust the system even when it feels inadequate. But when you are faced with the person who took everything from you, would you be able to wait for a judge to speak?